Welcome to Leyes Cotidianas, or Everyday Law, where we discuss the laws that affect you every day. Today we will be discussing the basics of criminal law, what to do if you or a family member is arrested, how do you bond out, what to do if you have to go to trial, what is an indictment. We will also be discussing the stand your ground laws. We hope that you'll join us with this and many other issues coming up next on Leyes Cotidianas. Welcome to Leyes Cotidianas, or Everyday Law, where we discuss the laws that affect you every day. Today we will be discussing the basics of criminal law, what to do if you're arrested, what to do if a family member is arrested, and in essence, what is the process. We have joining with us today to help us answer these questions and many more is attorney Mark Spix. Mark Spix is a criminal defense attorney. He's been practicing for over 30 years. He's an adjunct professor with Georgia State Law School. He's been involved in many high-profile criminal matters. He regularly speaks at seminars and provides expert commentary on NBC, Fox, CBN for the Atlanta Journal-Constitution and the Fulton County Daily Report. Thank you, Mark, for joining us today.
Thank you for having me. Happy to be here.
All right, let's start off with the situation where most folks find themselves potentially embroiled in the criminal system. And hopefully this won't be the kind of thing that happens, but oftentimes people do find themselves in a scenario where either they have been arrested or a family member may have been arrested. It seems like that's the first foray they may have. Can you give us a little insight into why someone who otherwise normally wouldn't be subject to a criminal matter would all of a sudden find themselves in the criminal system and potentially subject to arrest?
Well, that's an excellent question, and it's an important question because the truth of the matter is anybody can get arrested. You could go downtown right now and take out a warrant and say, while we were here, I bopped you on the head. I didn't, but if you say that under oath, they'll happily arrest me. And let's be clear for your audience, in this discussion we're talking about an arrest, when someone's freedom is taken away and they're actually placed in custody, not when somebody's given a ticket. But you can be arrested for DUI, you can be arrested for a host of traffic offenses, you can be arrested for domestic violence. Our police department here in Metro Atlanta, most of the police departments, have a policy that if they're called out on a domestic violence scenario, somebody is getting arrested. So 50% of the household is going to get arrested in that instance. And basically 80% of America has at one point in time been put in a position of potential arrest or actual arrest.
Okay. So it sounds as if, while this hopefully isn't something that is a regular occurrence for folks, there are lots of scenarios that you may find yourself in that all of a sudden throw you into the criminal process. Is that fair to say? Very
fair to say. And remember, you're just arrested. You're not convicted. You're just accused. Mm-hmm. And people are accused all the time of writing a bad check when simply someone else's check to them bounced and they couldn't cover the checks that they had issued. So it can happen almost serendipitously where you find yourself arrested.
Okay. So let's say, for example, someone who doesn't have any experience with the criminal justice system does find themselves in one of these unfortunate predicaments where they have been arrested. What is, in essence, the first step? I assume that the family members are in a bit of a panic. You know, it seems like the first order of business is, how do I get out? Can I get out? And what do I do? Can you give folks some idea of perhaps what would be the first steps that would need to be taken? Because it seems like there would be a lot of confusion at that level. The person that's been arrested really is incommunicado. So, you know, there's on the family members that are outside trying to get them out, there seems like they would have a lot of concerns, and what do they do?
Well, another good question, because the person who's arrested, the person whose freedom has been taken away, the first step that they want to take is to get out of jail. Right. They want to return their life to normalcy, whether it's your son, your daughter, your nephew, your husband, or yourself. Right. You want to get out of jail. And I tell all of my clients that the first step comes before you ever are arrested. And what you should have is some sort of a plan or the ability to present yourself in the best possible light at the drop of a hat. So I tell people to get their property records and keep them in one place where they can put their hands on them, their deeds, their tax records, and so forth. I tell people to put in the same place all their bank account information, who can sign for checks, what the account numbers are, where the bank or the credit union or the credit card is. I also tell people that they should have their passport and identification in the same place, and even a voting card if necessary, because if they're going to try to get bond at a hearing, they got to go someplace and convince a judge that they're not a flight risk and that they are a member of the community with ties to the community. So I also tell them to include in that same place at least 2 people with full contact information who could be contacted to come and help, maybe testify that they're honorable people and that they have ties to the community, maybe contribute financial aid, maybe help find a lawyer. And I also tell them to put in that very same place the card of some professional that they trust. It doesn't have to be a lawyer. It could be your preacher or your pastor. It could be your accountant, but somebody who's a professional who understands that you now need professional help.
Okay. So it sounds like there's a lot of proactive things that can be done, and hopefully you never find yourself in this scenario, but I can certainly understand the circumstance where if you do find yourself, or you have a family member, a son or a daughter, or someone else that's close to you that's in this scenario, you're sitting there and all of a sudden you're scrambling around, where's a property deed, where's all of this information, that might not be the easiest thing to get your hands on, you know, in a rushed circumstance. So I like the idea of going ahead and having that all prepared. All right, let's say, for example, that someone is able to get some of this information and have it available. You had mentioned property deeds and this proving that you've got some ties or connections to the community. Would you know, the names of the employers and things like that also be important to demonstrate, you know, the ongoing tie in the community, as opposed to someone who might be transient or, you know, doesn't have any particular reason to come back to this area? I mean, is that one of those kind of things?
Absolutely. You'd be surprised, but most people, when they're asked to provide the names of 2 people who could come and testify for them that they do have ties to the community, usually it is an employer.
Okay.
And that employer comes in and can say, the person's worked for me for 5 years, he's a valued employee, makes X amount of dollars, I want him back, I will continue to hire him. It's common sense, really, but I would tell people that they should add the employer to that list, unless it's the employer who's taken out the warrant for them for embezzling or something.
Right, then that's obviously going to be a little bit of a problem for them to get them to testify. All right, let's assume for the sake of argument that they are able to produce this kind of evidence, some kind of a deed record and so forth. How do they now take all of this information and then use it so that they can hopefully get out of jail in a relatively quick way and then move on to the next process? So how do they take this information? What's the next thing that they do in order to actually get out? I don't think people really know, well, what's the process?
Well, in a misdemeanor case, you're automatically bondable. Bond is set. If you're charged with a felony, you have to have a hearing in most cases, or there might be a set amount of a bond. But what you try to do is you get all this information, hopefully through a lawyer, but if you haven't got a lawyer yet, you can take all of the information and get it to a magistrate, and in a very informal hearing with relaxed rules of evidence, put forth proof that you have ties to the community and you're not a likelihood of flight, and that some bond can be put in place or some condition can be put in place to guarantee that you'll show up for your hearings and that you won't go do anything else wrong or harass a victim.
Okay, so the court's primary concern is we have you in our custody right now, you have been charged with a crime, we don't know whether or not you'll have defenses that will be able to allow you to prevail ultimately in those charges, but what our primary concern is to make sure that you come back and you complete the process. Is that their primary issue at that point?
And to protect the public and witnesses and the victim from further damage. That's why you'll usually see in a bond, don't contact witnesses, no further contact with the victim if there is one. But yeah, just to make sure the process is orderly and that you don't flee.
Okay. All right. We have to take a break right now, but we'll come back in just a few minutes and hopefully get to the next process. Thank you. We'll see you in just a moment.
Desde el momento en que ellos llegan a nuestras vidas, dan su primer paso, aprenden a andar en bicicleta. Hasta la preparación de su primer día del 5º grado es un reto para todos los padres criar un hijo saludable. Permítanos guiarle a través de un embarazo seguro y feliz. Aprenda sobre salud, nutrición e información educativa relacionada con el desarrollo de su hijo. Padres e Hijos Atlanta, una publicación del mundo hispánico. Recoja su copia gratis hoy. ¿Cuál es su tesoro más preciado?
Welcome back to Leyes Cotidianas. Today we're discussing the basics of criminal law, and we have with us Mark Spix, who is an accomplished criminal defense attorney, and he's helping us understand the process of what happens in a criminal proceeding. We talked a few minutes ago about normally what happens when someone gets thrown into the mix. They are arrested and the issue becomes, what do we do? You talked about making sure that you have actually a couple things in place before an event like that occurs, some information to demonstrate your ties to the community and so forth. Let's now step on to the next process and talk about, let's assume for the sake of argument that you are able to bond out. And you had mentioned that there's different circumstances. If it's a misdemeanor matter, it sounds like the process is fairly rote. There's an automatic amount set and so forth. If it's a felony scenario, then there's a hearing that takes place and it may be a little bit more involved. But let's assume for the sake of argument under either type of charge that you are able to bond out. What is the next thing that happens as far as the criminal process? Obviously your freedom or the individual's freedom is available now, but the process isn't over. In fact, it seems like it's really just begun. So what is the next thing that happens? I know there's an indictment process and then there's things that happen after that. Can you talk to us a little bit about what happens after you're able to bond out after the arrest?
Well, once you're bonded out, whether it be on your own recognizance or with a property a bond or with a cash bond or with a bonds person or bonding company, you're usually given a court date at which point in time your case will officially begin. If you've already been indicted, you get a court date pretty quickly.
Now, what's an indictment? I know people hear that, but I'm not sure everyone knows exactly what that means.
Indictment's not always used, but an indictment is a process where the officer who investigated the crime can go downtown or to the county seat, to the district attorney's office, and testify in front of a grand jury of citizens who are eligible to vote, who are serving on a current grand jury, give his evidence, and they vote whether or not to return the indictment. And most indictments are returned. I mean, the saying in Atlanta is you can indict a ham sandwich. Okay. They get what they want.
Okay. So if there's been an indictment, or even if there hasn't been an indictment, there is going to be an initial first hearing. Is that fair?
That's right. If you're not indicted and you're entitled to a probable cause hearing, you could have a probable cause hearing in front of a judge, and a judge would say there is probable cause and bind you over for further proceedings. And then eventually you would get a notice to come in for a formal arraignment, at which point in time you would answer the charge guilty, not guilty, no contest, one of the three. If you stand mute, the court will simply enter a plea of not guilty.
Okay, so that's the default plea that ultimately gets entered. All right. At this point, I assume that you are going to want to have some kind of a representation. You had talked a little bit about getting, having the name of a professional in some of the documents that hopefully you have available. Let's talk a little bit about how would you go about getting a professional. I may be changing a little bit of the little off topic from the process, but how would you go and get a lawyer in this scenario? I assume you're not going to want to go into court for this arraignment proceeding alone.
Well, quite frankly, not only do you not want to, I tell people that they're foolish to do that.
Right.
And forgetting what I tell people, if you've ever gone to an arraignment, you'll usually see a judge say to a defendant who's standing alone, are you represented or are you going to be represented? And if the person says no, they'll say, well, go over there and talk to the public defender and see if you qualify. Because the court prefers to deal with defendants through counsel.
Okay.
So you have the alternative of a public defender, Or you have the alternative of hiring somebody. And if you want to get into how I think you ought to do that, I'll be happy to discuss that.
Let's do that, because I think certainly for individuals who would not have otherwise had any experience in the criminal system, they may not know, how do I go about finding a reputable criminal defense attorney? Their experience may have been, they may have a divorce attorney, they may have accountants and so forth, but they may not have someone who has experience in the criminal defense area. So if you were one of those folks, what would you do, or what would you tell folks to do in order to find someone that they would feel comfortable with and that would have the appropriate level of experience for the circumstances they find themselves in?
Well, I would tell your viewers, and I would tell my own family, that finding a lawyer is, with a specialty is a lot like finding a doctor with a specialty. Most of us have a general practitioner who we see regularly. And if we go to the general practitioner and the general practitioner detects a problem with our heart, that's not the person who's going to do heart surgery.
Right.
They usually make a referral. And they're in a good position to make a referral because they're a professional, they share the profession, they've referred, hopefully, other patients to the specialists, and they will choose the best heart surgeon for their patient. I tell people, if you know a lawyer through church, or if you know a lawyer that you went to school with, or if you know a lawyer from Rotary, or from some other civic organization, or you ever bought a house and you had a closing attorney, to pick up the phone and call them and say, look, you know other lawyers, just like you know other lawyers. Mm-hmm. Can you recommend somebody for my loved one who has been, or my family member who has been arrested for bad check charges? Mm-hmm. Can you recommend somebody to represent my family member who's been charged with fighting in a bar?
Right.
And the lawyer, I think, is going to give you an educated response and a little bit more discerning response. Several things I wouldn't do. I wouldn't hire a lawyer because of a refrigerator magnet. Okay. I wouldn't hire a lawyer because I saw his or her name on a bus bench. Mm-hmm. I wouldn't hire a lawyer whose name simply appears on the back of a telephone book, because to be honest with you, I wouldn't even buy a stereo under those circumstances.
Right.
I would do more investigation. And if you go to a lawyer that you've used or as a friend, and the lawyer says, look, in our community, in the legal community, Charlotte Perrell is the person to go to for a malpractice case. Or in our community, so-and-so is the lawyer to go to for a DUI, or a fight, or a bad check charge. And I think what you're getting is a more discerning choice.
Exactly, and I was, just to add on that, lawyers commonly expect these kind of phone calls. We get those kinds of phone calls, I'm sure you get those kinds of phone calls. So it's not uncommon for a lawyer who is in a particular area who just happens to know someone to say, oh yeah, I'll get you to the right person, or at least get you started down the path to the right person.
Well, and to be honest with you, even judges on occasion will give you a name.
Right.
I have a friend whose son was arrested in a remote part of Michigan, small town, not a large bar, had absolutely no idea what to do about getting his son out of jail. And he called up a judge and asked for a suggestion, and the judge says, I'm not going to recommend anybody or tell you who's good or bad, because I don't want that coming back on me, but I will tell you this person is ethical and this person works hard. Well, that's a pretty good recommendation.
Right, exactly. So don't be afraid to go to a lawyer who you know isn't a criminal lawyer, because they can at least get you down the right path. Okay, let's change topics just a little bit. And well, you've gone through the process and so forth. Let's talk about a particular kind of case that has received a little bit more media attention of late, and that is the case where you have the defense called Stand Your Ground. Obviously, there's been some high-profile case about that recently, and the question I think a lot of people have, and a lot of people ask me, and I don't do criminal work, is, well, how does that Stand Your Ground work? Are you able to use that as a defense automatically? When can you use it? Do you have to be in your home? Does it matter where you are? How do you prove that you were attacked first, and so forth? Can you talk to us a little bit about the Stand Your Ground law? What does it mean in Georgia? And in what circumstances would someone be able to use that as their defense, or at least know what it encompasses as they may find themselves faced with a situation where they've been attacked or someone is intruding on their property?
Well, it's different in each state, what you're seeing mostly in the media right now is the Florida case. The Georgia law is a little bit different. Georgia law says that you have a right to defend yourself, and you are immune from prosecution if you're simply defending yourself. But simply defending yourself means that you weren't the protagonist, that you weren't the aggressor, that you didn't start things. Now, if you have a lawyer or a public defender who has interviewed you and says, geez, under the circumstances you've just described, I think you have a right to assert immunity in defending yourself. That lawyer would file a motion for a hearing for the judge to determine whether or not you were simply defending yourself reasonably and using reasonable force with a reasonable apprehension that you're going to be harmed.
Let me stop you right there. Hold on. Because you said a couple things that sort of struck me. You said for a judge to decide about whether or not you've had this reasonable apprehension and so forth. Why would that be something for a judge to decide?
Well, because it's a different law and it's a different treatment. If it was simply a defense, the prosecution would put on its case in front of a jury if you asked for a jury trial. And then you would, as a defense, put on, after going through the whole ordeal of selecting a jury and being put on trial, you would put on a defense and say, I was simply defending myself. The immunity provision under the typical stand your ground law says you can't be prosecuted. So you file a motion saying, I can't be prosecuted for this. And I'm going to prove to a judge before we even seat a jury that I was simply defending myself and that I had a right to do that.
Okay.
If the judge so finds there's no jury stricken, the charges are dismissed because you're immune from prosecution. Just like you've probably read where diplomats, when they come to the United States, are immune from certain prosecutions.
So it sounds like with the stand your ground law, it's not just your run-of-the-mill defense that gets thrown in with all of the other evidence in a whole case once it goes all the way through, but it's actually got a lot more weight to it. If a judge looks at all of the evidence preliminarily and goes through, and I assume the hearing is going to have testimony with witnesses and so forth, is that correct? Okay.
Put on whatever you want.
Okay, so it's a full hearing, there's witnesses, fact witnesses and so forth, but it's just with the judge. And the judge is looking at it to say if he or she believes that in fact all of the elements that are necessary to prove this, if that's the case, you can't even be, you're immune. As you said, you can't even be charged, and the case doesn't even get to go forward. So that's a pretty significant defense, it seems like, to me. I mean, it's different than just, like I said, the regular garden variety defense in a particular case.
It's very significant. To be honest with you, it's appropriate, because if you've done nothing, if you were not the aggressor, and you simply defended yourself, why should you have to spend all of that money and go through the anxiety and the ordeal of a criminal trial just to put up your defense that should preclude you from being prosecuted at all?
All right, let's go back to the process. Let's assume for the sake of argument someone's already been arrested, they've gone through the arraignment process. Can you give us a sense of the cases that have already moved past an arraignment? How many of them actually go to trial, and how many of them actually get plead out or get resolved in some way? Do you have any statistics on that, or I don't think folks have a good sense of what that breakdown is?
Well, the judiciary and the Department of Justice, nationally and state by state, actually maintain statistics on that. And I believe the statistic for this year is way over 80% of the cases nationally are resolved through plea bargains.
Okay.
Leaving less than 20% actually going to trial.
All right.
And if any of your viewers have ever gone down to watch an arraignment or appear on behalf of somebody, a family member who was charged, they see the multitude of cases that are down there, they've got a pretty good idea that not all of them can go to trial. If every one of those people that are charged with a crime demanded a trial, the system would come to a screeching halt. The prosecutor knows that, the judge knows that, and the defense knows that, And quite frankly, that works well for the taxpayers because they don't have to foot that huge bill. And if all of those criminal defendants clogged the courts, then businesses wouldn't be able to have access to the courts to resolve their disputes. Neighbors who have a boundary line dispute, a civil case, wouldn't be able to have access to the court. People who are getting divorced wouldn't be able to have access to the court because it would all be eaten up by the 100% of the people that want to go to trial. It wouldn't work.
Well, and it sounds like it actually is a good thing so that the matter can ultimately get resolved in short order and the risk can be dealt with the folks that are potentially charged. They can work into some kind of a first offender issue, or they can do something so that they can have some finality to the process. Is that fair?
Through the plea bargaining process, you have many more alternatives, many of which are more fair to everybody.
All right. Thank you very much for joining us today. I think that you've definitely helped us have a better understanding of just some basics about criminal law and what we need to do if someone finds themselves in this predicament. Thank you again. Thank you for joining us on Leyes Cotidianas, and if you would like this and more information, please join us on leyescotidianas.com.
Leyes Cotidianas les llega a ustedes gracias al generoso apoyo financiero de la Fundación de Justicia Civil del Estado de Georgia. Mundo Hispánico, el vocero de la comunidad hispana desde 1979. La estación transmisora WPBA no tiene licencia para practicar leyes en el estado de Georgia. WPBA y los patrocinadores de este programa no son responsables por las opiniones expresadas ni la información proporcionada por los abogados en este programa. Este programa se ofrece como un servicio público. El objetivo de este programa es de informar y educar y no de proveer consejo legal. Si usted necesita consejo legal, favor de consultar a un abogado.